Good afternoon, everyone. We're pleased and honored to have you at the Thursday meeting of the House Judiciary Committee. Business-wise, first of all, we do have a quorum present. We concluded the meeting on Tuesday without having complete the hearing as far as public comments on the House Resolution 108. Mr. Duncan. And you may have, you want to come forward. I think you had finished your comments. Is that right, as I recall?
Yes, sir, that's correct. I wanted to address a couple of the comments that y'all had raised with me.
All right, why don't you do that, and then we'll call for the others.
Thank you, Mr. Chairman and committee members. I'd like to take a minute to thank many of you on this committee for the conversations we've had in the last day and a half. They've been very informative and engaging, and so I appreciate that, and thank you, folks on both sides of the issue. I want to address the two main issues that I think were raised at our last hearing. The first was in regards to the verbatim language that was used in the constitutional amendment. Going back to the process, looking back through the notes, the verbatim piece was from a piece of legislation that was brought forward by Speaker Pro Tem Jan Jones and Representative Lindsay, and I believe it was the 2000 session. That was used as the model template, 2009. And that was what was brought forward. It came through this committee and made it to the House floor and narrowly missed the 120 votes. The other 5 states that we talked about were very similar in nature, but not exact. And I wanted to make sure I brought that point forward, being that there are constitutional amendments and weaving them into their constitutions required a little bit of difference in language. So I wanted to make sure I addressed that. The other concern, Mr. Chairman, that you had brought forward was talking through the broad stroke that this could potentially paint on additional secret ballot locations, such as city councils. I think Representative or Chairman Jacobs brought forward, county commissioners, and also here at the Capitol. We have put, hopefully you have in your folder, a proposed substitute that we've brought forward for this that we think addresses that and narrowly limits where this goes forward, and just applies to elections, labor elections.
In 2009, was that a constitutional amendment or just a bill?
It was a constitutional amendment, sir.
Okay.
I've also brought Representative Kelly with me, who is a co-signer on this legislation and has helped me through this process. I brought him to help me answer any technical questions.
All right. Any technical questions of Mr. Kelly?
I just want to say, Mr. Chairman, that I think this is a good common sense piece of legislation. You know, citizens have the right when they go to the ballot box to vote in a secret manner for when they elect us, and I don't see any reason why employees, when being subjected to a vote for a labor organization, why it should be any difference. This is a bill that's ultimately good for Georgia, our workforce, and for our economy in terms of economic development. We're proud to have received a letter of support from both the Georgia Chamber of Commerce as well as the National Federation of Independent Businesses.
Thank you, sir. Any questions by members of the committee to the presenters of House Resolution 108 at this time? If not, we thank you for your comments, and I'm going to have 3 other people, I believe, wanting to address the committee. Yvonne Robinson.
Thank you.
If Ms. Robinson, you're here.
I am here.
All right. If you're able to come forward and would like to take a seat and give us your name and who you represent.
Okay. Thank you for allowing us to speak. I am Yvonne Robinson. I'm the Secretary Treasurer of the Georgia State AFL-CIO, and we represent over 210,000 folks in Georgia.
All right.
Thank you very much for allowing
Yes,
us to
ma'am.
speak. I just want to kind of go through, there's 2 other folks that are going to address some of the issues that we have with the bill, but I do want to go through a summary of issues. I'd like to talk about the Arizona bill that was brought before you, that there were 5 states that have this similar language, and Arizona was the only state that took this to trial. The NLRB, the National Labor Relations, took it to court, and I think there's a misrepresentation on what happened in the court. It says that we did not win it, but it was only because it was prematurely filed.
Who's we?
The NLRB.
Okay.
The NLRB, Arizona did not win it. The NLRB just made the decision that we can't rule on this because it hasn't been tried. No one has been denied the
Okay.
right. So if you guys, I think
You have really what you cause. You have to have the cause joined
Exactly.
by failure of the ability to do otherwise
Yeah.
than what the Constitution
yes,
provisions.
and we have another speaker that will speak more, give you more information on that bill. The other 4 states, it has not went to trial because there has not been a cause and effect. So this has not been tested in those states. The NLRB is ruling that that they will take it to court as soon as there's an opportunity because they believe that it's preempted by federal law. The federal law has been in place for years, and this is a means for employers, the union, and workers to peacefully decide on their own to have a union. There has never been the only violations that there have been are, there are violations, and I'm not going to sit here and tell you that they're not, but a majority of the violations are with the employer. The employer, the violations are filed against the employer and for intimidation. There are rules that are set by the NLRB for elections to prevent this from happening. And so the state, this is redundant for the state to put this in a, I guess you say, save our secret ballot. We already do a secret ballot on all other elections. And so if folks want to come forth and say we want a union, we don't understand why the state wants to say, no, you can't do that. There's the other thing is the unintended consequences that were not mentioned is that if there is a company that has employee who own the company, any decision that's made by that company will have to go through an employee secret ballot vote, any decision. And so that's
What type of decisions you mean?
a corporate decision. So if you want to sell part of the company to Google, every employee that has stock in that company will have to be part of a secret ballot. Or if you want to make changes or merge, everybody would have to vote. So those are things that are unintended consequences that the company would have too. We think that the card check is voluntary. If the company doesn't want it and the union doesn't want it, it doesn't happen. It doesn't happen. It's just another way. Many times companies and employees and the union feel that, okay, this is a way that we can do this. Everybody's happy. We're done. So we don't understand where this language is coming, and it's directed at the unions. And so we ask that the committee vote against this because of all of the unintended consequences. You'll hear from someone that will give you more information on the law, and you'll hear about a few companies that do this all the time, and they enjoy the privilege of doing it, so that they have a harmonious relationship.
Do it all the time. What is it that we're talking about as being it?
A card check.
Card check.
Card check. Sorry,
Okay.
card check. The card check, and
Thank
it's
you.
in So that's
I think we've got at least one question. Ms. Kelly, is that yours?
yes.
Yes, sir, Mr. Chairman. A few questions, if I may.
Yes.
Ms. Robinson, thank you for coming before our committee today. So just so we're clear, has this been found, the language that is in this legislation, has it been found unconstitutional by a court of law today?
It has not been found unconstitutional, and it has not been found constitutional.
Next, you talk about the peacefulness of card check.
Yes.
How would making a secret ballot process make it any less peaceful?
Sometimes it's the agitation that sometimes employees feel intimidated because it's a longer process. Employers enjoy the privilege of it, and employees enjoy the privilege of it, because it's a simple, you sign a card, you have a right not to sign the card,
If you're not intimidated by the people you work alongside of every day to sign.
or if you're not intimidated by the employer not to sign the card. It
It
goes both ways.
Okay, so doing that secret would maybe clear up some of that.
There's still intimidation during the secret ballot, so this doesn't always clear up. But if you have a company in the union and the employees all working together, there's less of a chance of that happening.
And finally, you talked about some unintended consequences.
Yes.
When you said that bills where a company would be sold or would require secret ballot, and you're talking about shareholder elections.
I'm talking about shareholders of folks who are employed by the company who are shareholders. Because they are employed by the company and they are part of the shareholders, this is the,
If it would change their employee representation, because that's what we have specifically narrowed this language to say, is employee representation issues only. I don't see how you can in good faith stand before us and say that it's going to influence shareholder elections differently.
well, because employees are representatives of that company in their stocks. So, interpretation can go both ways. And this leads to misinterpretation.
All right, thank you. Next is, yes, ma'am.
Thank you, Chair. Two very quick questions. Are you aware of employers who prefer to use a card check?
Absolutely. And there will be some folks that will be speaking to that. But I can tell you that currently AT&T does it. Kaiser Permanente, Budweiser, Anheuser-Busch.
So the language in this bill, would that take away their right to have decide how they want their unions to be formed?
It will take away the option if it is, but we feel that it's preempted.
One more follow-up, Chair, if
Yes,
I may. Right now, and I don't know a whole lot about unions, in order to do the secret ballot now, both the unions and the employers have to agree.
Absolutely.
So the way that it is now kind of leads to people working together to come to a decision on how to work.
A labor management cooperation.
No further questions. Thank you, Chair.
Thank you. And Ms. Oliver, is that yours?
I'm sure Mr. Kelly didn't mean to imply that you were in any way acting in bad faith. I'm sure he didn't do that. In relation to the issue of taking away employer rights, do you know whether AT&T, who I'm sure is a member of the chamber, has been in consultation or advised or has a position on this bill that the chamber is taking away their rights?
At this point, they're taking a no position,
Thank you.
not for or against.
Okay. We better let them speak for what their position may
Right.
be.
Well, I'm
I
sorry.
understand. Shouldn't-
Hearsay.
I appreciate that. No one else seems to have a question for you, Ms. Robinson. I appreciate your appearing before us today.
And I appreciate
Thank
you
you,
giving
ma'am.
me a chance
Yes,
to
ma'am.
appear. Thank you.
Mr. Tony Tilley. Come forward, Mr. Tilley, and
Thank you, Mr.
identify
Chairman.
yourself and tell us who you represent if you're representing a group.
Thank you, sir. My name is Tony Tilley. I'm with the Communication Workers of America. April 16th of 1990, Southern Bell Telephone and Telegraph hired me as a service technician. April will make 24 years that I have not only been an employee of the telephone company, climbing telephone poles most days. I'll be into my truck on Saturday, knocking on
Rain or
doors
shine.
and going in offices.
Snow, sleet.
Yes, sir. This morning was a good day not to be on a telephone pole, by the way. But this bill directly not only takes away my rights, but it takes away the rights of my employer. First of all, because I felt there was some testimony the other day that wasn't really clear, I would like to try to clear up some points, even though I'm not a lawyer, I'm a phone man. I don't know how many of you are labor lawyers, so I would like to make some points. Number one, it was mentioned the other day that card check is an untested policy that started in 2008. The National Labor Relations Act was written in 1935. The original language was through a ballot or any other suitable means. In 1947, the employers convinced Congress to change the language to include card check at the employer's discretion. So here's what happens in a situation. For you to get a union, if you don't have one, number one, you have to have at least 30% of your employees so mad at you that they're willing to go to the National Labor Relations Board and petition for an election. Now understand, if you come to me as a Communication Workers of America union bosses, that we're like to be termed as,
Stewards.
I'm going to inform you that unless you can get 70% on those cards, you might as well quit. Because the company, if you don't have at least that many, is automatically going to request a secret ballot election. Because during that time period, they can spend that 30 days or however long having one-on-one conversations with their employees. Has been known in many instances to terminate at least one employee that is involved. Now understand, once that one employee, even though they end up normally getting their jobs back with back pay, the damage is done. So therefore, not everybody wants to go through this process. Now let's talk about how it affects my employer. And I'm here to tell you that AT&T has not come out one way or the other to me on this bill, so I'm not speaking for them, but they are my employer. Now, why Bell South in your mind is gone, Bell South, as far as we're concerned, is still here. When we organize over our 9-state Bell South region. Since AT&T bought Bell South, we've had 2 inter-organizing campaigns. When we first were bought, understand Singular was dual owned. Part by SBC out in Texas, part by our parent company Bell South here in Atlanta. The SBC side of the company was already unionized. Bell South Mobility was not. So they came to us and wanted us to get the company all organized so that everything was on board legally. Now, 2 years ago, our new UVerse technicians that had been working with our company for 3 years, non-union. So I'm at a house, a UVerse technician's here, he's non-union, I'm here. The turnover rate in our company was so high that, again, AT&T approached us and asked us to organize these folks. 86% of them signed a card saying they felt they needed union representation. Now understand that signing a card saying that I believe I need a union to represent me to try to talk about benefits and pay does not make you a union member. You still have that personal choice, the final choice, as to whether or not you want to sign a membership card or not. So part of my co-workers are non-union. They get the vacation, they get the benefits, they get the sick, they get everything I get. They don't pay a dime. Now understand that this way of doing business under the National Labor Relations Act, the Supreme Court of this country ruled it as the law of the land, that it is constitutional that we have 2 means. And something that may be interesting to some of you, in that same Gissel Packing, NLRB versus Gissel Packing Company, the Supreme Court ruled that the employee has a personal responsibility to know what they're signing. Understand, this does not take away anybody's rights, but the bill, and I have not been able to see the bill with the new language, by the way, but I have to assume it's based something on the Arizona.
It'll be published.
I appreciate it. I assume it is on the Arizona bill language. Now, understand that Arizona bill, right up front, Arizona mentioned that they still have card check. It does not take away card check in Arizona. It's still there. So that was not even discussed in the motion. The NLRB pulled back the preemption part of the bill in Arizona because the Arizona said that they. Now I talked to the writer on this bill, and I don't believe that is his intention. He does not want card check at all in this state. Now, so you're going to tell my employer, AT&T, that when we want to do a intercompany organizing campaign, that we can do it one way in the other 49 states or the other 8 states if it's a Bell South district. But in Georgia, we're going to restrict your rights, and we're going to make you live up to different rights in this state than you do in other states. Now, I represent people in all 180 House districts. I'm elected just like you. They elect me to be their voice. Now, the majority of those people elect their representatives, and especially in my county where I live, they believe in less government, less business regulations. They believe in personal responsibility. This bill takes away all of that. This bill is bad for Georgia just because it has not been raised as constitutional nor non-constitutional in any of these states. In the Arizona ruling, it told them they needed to walk a very fine line, that we are allowed, without preemption, to set up dual courts. If the state of Georgia, as taxed as our court system is, wants to start taking in these kind of issues, they have a right to. You can take our judges and you can take our court system and we can start fighting employment business and union business in our state courts before we turn around and file at the federal level. And then we can add costs to our businesses in this state and understand, unlike 361 that's in court right now from last year, that the unions are paying the fight, the taxpayers in Georgia will pay twice to fight this bill. They're going to pay the taxes at the federal level for the NLRB to fight against it, and they're going to pay you, the state of Georgia, to fight for it. I believe that's a waste of our time. I believe it's wrong, and I believe it's against what most of our folks run on.
Thank you, sir. Any questions of Mr. Tilley? Yes, sir. Mr. Kelly.
Earlier at the beginning of your testimony, you referenced that most union elections are tried first through car check.
No, car check starts the process.
Car check starts the process.
Yes, sir.
And then you turn those in.
Mm-hmm.
And then eventually you have a secret ballot that you said ended up, because of a 30-day window between the initial and the other, that there were some nasty things that occurred. You said just from the employer. I imagine it happens on both sides. But why not just do a secret ballot then initially?
Well, actually, it's the employer's choice, not the employee's choice. And that's where all this came from. Is back before President Obama was elected the first time, there was a bill in Congress called the Employee Free Choice Act that would have taken the right to choose which way you want to have this done and taken it away from the employer and give it to the employees. Now understand, that bill died his first term. He didn't want it, he didn't back the unions on it, and it's dead. And I will say the 501(c) groups did such a great job of demonizing it that it's dead. Now understand that I've got some statistics from the NLRB, and I agree with you. There is intimidation on both sides, and we approached, because when I first got involved in this bill, I was involved because Representative Duncan said he wanted a bipartisan bill. So I went to him to talk about how can we make a bipartisan bill. And the way you do that is you put good, strict teeth and penalties into either side. Either side. Understand, my latest thing shows that there was about 6,500 union complaints against their unions for intimidation. There was almost 25,000 against companies. So it is on both sides, and there's a way to fix this, but this bill is a facial bill. It's all sugarcoating and lipstick. It does not fix the problem. It does not address the problem. It takes away my rights as an employer, as an employee, and it takes my employer's rights away to choose to do something in Georgia that they do everywhere else a different way.
Just a minor correction. It's not a bill, but a resolution.
A resolution. I
or
apologize.
a constitutional amendment.
Yes, sir.
Which is a little different. Thank you, sir. Mr. Mabry.
Thank you, Mr. Chairman. Just on his point, in this room right now, I'm intimidated right now by everyone here. You think we should go in the back room and have a secret vote?
Well,
That's
Yeah.
inappropriate
No.
question. You got a question for?
That's
No
it.
question.
No,
All right,
that's-
that's fine. Thank you, Mr. Tilley. That's all the questions we have at this time. We have one other person, Mr. Eric Taylor, who would like to address the committee. And Mr. Taylor, come forward.
Mr. Chairman, I'd like to pass.
You pass? All right. Well, with that, that's all the public input. We're going to cut off or terminate further public comment. As I said, we were just going to finish the public comments today. There's not going to be further consideration of the bill. There has been a new new resolution provided, and I want the members of the committee to have a chance to study this. And let me ask of you, Mr. Kelly, I believe the language for the constitutional question was also modified as a part of your new draft, which we're looking at as LC 362486S, correct?
Yes, sir.
Okay. So we will not have a further vote or consideration of the bill at this time, but the committee will have a chance to review the proposed substitute resolution. Next bill we will have will be House Bill 1, and I'm going to move over and let Vice Chairman Fleming chair the committee during this portion of the hearing.
We'll give just a second for the room to clear out. The chairman has instructed that we'll move ahead with House Resolution 1161. 1161.
No, it's not on the agenda. Better go ahead and get a copy of that. That wasn't put on.
Judge Caldwell, it's a very short constitutional amendment, so why don't we let you tell everybody about it, and by the time you get through talking, they'll probably have the copies made, and everybody will have a chance to read it. It won't take but a second. Go ahead.
This resolution would have to go before the voters for a constitutional amendment. Does one thing and one thing only. Presently, the law says to be a district attorney in the state of Georgia, you must be a member of good standing of the state bar. You must live, of course, in the judicial district that you're going to run in, and you must have been a practicing attorney for a minimum of 3 years. This resolution, as requested by the District Attorneys Association and the Prosecuting Attorneys Council, moves with qualification from 3 years to 7 years. I think it's a good resolution for
Same judges.
exact same judges are 7 years. And the reason that I think that it's a good resolution, I was a district attorney, but we are seeing so much litigation now, particularly in the capital punishment area, that, to be quite honest with you, an attorney that has only practiced 3 years, in my opinion, should not be faced with that responsibility. And it's the DA, he or she, that makes the determination, not a judge, but just that one person as to whether you seek the death penalty or not. That's number one. And I think they should have more experience. I can speak personally to that because the second case I ever tried as DA, and I had not been a DA for over 3 years, but just 3 years. Second case was a capital punishment case. Also, the offices today have expanded so that there are so many assistants, investigators, that you need somebody, in my opinion, that's been there a little while longer to be able to operate those offices. And that's all it does. It changes a 3 to a 7, and it's identical to judges. And Mr. Porter, the district attorney, is here, as well as the prosecuting attorney's counsel, if you want them to speak on it.
Put 2 before the 7.
Oh, yeah.
I'm still qualified.
I was going to ask if Mr. Porter could still practice as a DA. I don't know. Can you, Mr. Porter? Could you do that? Okay. All right. Okay. We need to put a 3 in front of the 7. Is that right? Okay. All right. Thank you, Judge Caldwell, for that introduction. Is there anyone here today who, and we're passing out, I believe, the copy right now of this constitutional amendment, H.R. 1161. Anyone here today, on the committee, first of all, we'll start, would like to make comments on the bill? Anyone on the committee? Well, let's see if there's anybody here that in the audience that would like to speak to the bill. D.A. Porter, you want to come on up?
Thank you, Mr. Chairman.
Please introduce yourself.
My name is Danny Porter. I'm the district attorney for Gwinnett County. I've testified before this committee before. I want to give you some idea of the basis of why we requested Judge Caldwell to, and I've gotten in the habit of calling him Judge Caldwell, but Representative Caldwell, to introduce this constitutional resolution. In the last 3 months, I've made the decision 3 times on whether or not to decide to seek the death penalty on individuals who are charged with murder, and the law provides me with the sole authority to do that. Different district attorneys do it different ways, but I make that, in the end, the DA is responsible for that. I can remember when I had 3 years under my belt, I had tried half a dozen cases. I was in the same boat as Judge Caldwell. My first death penalty case came when I was 3 years into the bar, and it is a different ball game now. It is a different ball game as far as the complexity of decisions, and it is a different ball game in terms of the complexity of running an office with all the federal and state regulations. And I would say that certainly the decisions that we have to make are on a par with a Superior Court judge, and I think fundamentally a person who wants this office should be fundamentally as qualified as a Superior Court judge, and we would ask for the committee's support on this resolution.
Mr. Porter, also, it goes without saying, but just to ask the question, of course, district attorneys are elected from the exact same judicial circuit as the judges and have to be elected circuit-wide the same way they do.
That's correct. That's correct. And one thing I would note, we have one DA who was recently appointed by the governor, and I know he certainly doesn't have 7 years, and he thought we were out to get him. There is a grandfather clause. There is a grandfather clause.
Anybody presently in stays in.
Right. Okay. Any other members of the committee like to ask Mr. Porter any questions about this? Okay.
Thank you, Mr. Chairman.
Thank you so much for coming today. Anyone else in the audience would like to testify regarding House Resolution 1161? This reminds me of when I first started practicing law. An older lawyer in my firm told me, he said, "Son, this case requires no hair or gray hair." And I'm beginning to qualify for one of those. All right. There is, I think...
Make a motion.
All right, there is a motion due pass by Representative Oliver. There's a second by Representative Welch. Any discussion on the matter? Mr. Chairman.
I'll look at the language on the ballot, and I'd like to suggest what we may want to do here. I'll read out loud so everybody can hear it. Shall the Constitution of Georgia be amended so as to increase from 3 years to 7 years a time for which a district attorney shall have been an active status member? I think we need to change that to, for which a candidate for the office of district attorney shall have been an active status member of the State Bar of Georgia.
I have no objection to anything Chairman wants to put in, Mr. Chairman.
All right. Well, I think the better language, because you're talking about someone who's standing for the office, whether it be an incumbent or a new one, so it's a candidate for the office. Mr. Jacobs, I'm sorry.
Mr. Jacobs.
That seems to make the question read that you need to, in order to be a candidate, you need to have been a member in good standing of the State Bar, when really this goes to qualifications to hold the office, which is generally either clocked from in terms of residency, it's always from the date of the election, which is the general election. In this case, I guess it's to hold the office, so it would be from the date you are 7 years from the date you're sworn in.
I'm saying the point I'm making is we're not talking about people who are just district attorneys. And that's the way it reads.
Mr. Chairman, one thing in regard to Mr. Jacobs' point, and Mr. Bergman brought this up, and I can always rely on him to find a hole, is the language that's suggested as far as a candidate would allow someone with 3 years' experience to be appointed, but you would have to have 7 years to actually get your name on the ballot.
Well, let's say 7 years for a person to hold the office of district attorney.
That
time for
Okay.
a person shall be qualified to hold the office of district attorney.
And my point was only that this isn't about candidates. This is about exactly what you right. That's right.
7 years for which a person to be qualified to hold the office of district attorney shall have been a member of active status. So I think that's the language we're trying to look at. Ms. Travis?
Ms.
You
Travis?
agree or disagree? You got comments?
I was trying to find it in the Constitution now, and I'm not. I got your first language about the candidate, but did you change it after that?
Yes, it was.
Keep it up.
All right, we'll try and
What's new?
I don't keep up myself too long. All right, 7 years. The time for which a person shall be qualified to hold the office of district attorney shall have been an active status member of the State Bar of Georgia, and provide that any district attorney holding office on January 1, 2015 shall continue to be eligible to hold such office. That's what we're trying to do. Do you get it?
No.
All right, well,
Just tell me the word you're at.
all right, after
On line 20.
on line 20, do you have a copy of the bill?
Yes.
All right, those resolution. Time for which a person,
After the first time you see the word A on line 20.
A, before district attorney, for a person to be qualified to hold the office of.
Adding for a person to be qualified to hold the office of.
District attorney is already in there. All right.
Now I'm with you. Thank you.
All right. Representative Lindsay?
No, I was just find myself in the nice position of agreeing with District Attorney Porter, and I was going to raise the same point he did. Y'all have already cleaned it up.
All right, thank you. Mr. Jacobs?
The only suggestion I would have on that is maybe after person take out 2B, so it would read to increase from 3 years to 7 years the time for which a person qualified to hold the office of district attorney shall have been an active status member.
Okay, I'll take that as a friendly change.
I'm sorry. I didn't write this, so I'm really not following along.
All right, Mr. Jacobs, say that again for Ms. Travis.
The way the amendment would read then is after A,
On line 20.
on line 20, insert person qualified to hold the office of. Person qualified to hold the office of.
District attorney. Read on.
Right. Okay. So as to increase from 3 years to 7 years the time for which a person qualified to hold the office of district attorney shall have been an active status member of the State Bar of Georgia, et cetera, et cetera.
That's good. How's that look, Ms. Travis?
Great.
All right. Okay.
Offer that as an amendment.
There is an amendment. Well, first of all, let's see. Update. Do we have a motion to pass? We did have. All right, and we had a second, and this would be during the discussion an amendment offered by the chairman. And is there a second? Second by Mr. Jacobs. Any discussion on the amendment? Does everybody have that? If there hearing no discussion, all those in favor, please say aye. Any opposed? The ayes have it. The next issue in front of us will be, if there are no other amendments, will be the bill itself. Any discussion before we vote on the motion of Ms. Oliver for approval? Hearing none, all those in favor of approval as amended, please say aye. Aye. All those opposed? In the opinion of the chair, the ayes obviously have it. The bill is passed. I'm sorry? By committee substitute. All right, next on our agenda is HB1. Mr. Chairman, you want to go ahead and present that to us?
Thank you, sir. HB1, to take a moment to give a little brief history. The bill was worked on for better than a year with the group that I had as a working group, including the prosecuting attorneys and several others, and we came up with a bill. Not saying everybody was supportive of it, but we came up with a bill, and that bill started last session and was heard in this committee. Came out of the committee, went to rules, and great deal of opposition from some law enforcement agencies, and the decision was made with the speaker and myself basically to hold up further consideration. The speaker wanted to put together a working group and have that group study HB1, and during this past time between last session and the beginning of this session, we had a committee called the Ralston Committee, which was made up of a number of legislators, including Representative Caldwell, Representative Kelly, I can't remember, Representative Welch, who else, and yeah, Representative Rutledge on there, and I think anybody else, and yes, Ms. Evans. So we had a good representation of House members, as well as we had the group of district attorneys and also prosecuting attorneys council serving with this group, and we had sheriffs meeting and serving with the group, and we went through a complete review of the bill, discussing the issues that were of concern to the groups, and I'll raise a couple of them just because we did have some, well, I felt substantial change based upon the dialogue and understandings that we were trying to reach. We had previously set a higher standard of what we call the clear and convincing evidence before there could occur a forfeiture of property. This was my suggestion, and my suggestion based upon, I felt it was a very drastic act of the government when it takes property after being seized and goes through a forfeiture, and I felt there was appropriate need to have that standard higher than just the preponderance of evidence. Through the discussion of the committee, I saw the reasons why, from a prosecuting attorney's standpoint, that they felt the need had to be there because you do have, and this is going, let me back up and say, this is going to set up a whole new civil chapter under the Civil Practice Act, be Chapter 16. We're setting out a civil procedure, and of course most civil actions are based upon a preponderance of the evidence. It also had concerns from the district attorney's standpoint because of the fact that you may have someone who is using a third party to hold ownership of property that's being used in criminal conduct, and so the difficulty then may be, how do we have the direct necessary proof to show this relationship and knowledge on the part of this third party property holder, whether it be an automobile or real estate or whatever it may be. And so I could understand from that standpoint. The main thing I was wanting to be sure that we saved is the fact that a person who has potential loss of their property, that if they are wanting to challenge this issue, that they're going to have an opportunity to appear before a judge, a magistrate, and set forth their belief why they consider the conduct of the state in trying to take the property in forfeiture is wrong. And let that magistrate hear the facts, the circumstances, the evidence from all sides and come to a decision. It's not a jury question, it's a question to be resolved by this magistrate sitting as a protector of the people and their property in this state, as we have set up under our governing system and our judicial system. So I felt at least comfortable enough saying, okay, we'll allow, I would feel comfortable enough to allow that threshold to be back to the point of the preponderance of the evidence. I think the law enforcement people felt more comfortable, of course, with that, and I know the DAs did. That was one major area. The other area I dealt with, what was the thing about Gary, the 25,000. Yeah, 25,000. Again, the same concern I had was that we were having what we call non-judicial acquisition through forfeiture of property, meaning that because the threshold was high at 25,000, a lot of people were not being given the chance to appear before the magistrate with their concerns, because even though they may have expressed a concern and did not follow the specific currently existing language in the law about the procedure to be followed and getting a verification signed statement with all the information specifically listed, they were thrown out of court. The district attorney, the prosecuting attorney would say, sorry guys, you just didn't follow the law, so you don't have a chance. That to me was an unfair and a disadvantage to individuals, especially people of lower monetary means, to have the opportunity again to appear before a magistrate and have this question heard and resolved by appropriate arbiter of these facts. So with that in mind, we had further discussions. There's language in the bill now that we'll leave it at $25,000, but if somebody walks in the district attorney's office and says, I'm unhappy you're taking my property and it should not be seized and then going through a forfeiture, the state acquired this property, the district attorney is going to take an action from that standpoint and file it with the court, and there will be an action filed where that individual receives pleadings and has an opportunity to respond to those pleadings. If the response by the party claiming interest in the property does not meet, again, the specific things that are necessary to be provided as an answer, the remedy is the district attorney will file a motion for a more definite statement, just like we do in civil actions. So the purpose is to say, okay, you didn't give me everything I needed information-wise. I'm filing a motion, and the court will then give direction to that party to give the specific necessary information required to be included with the response by the person claiming interest in the property, and a timeline will be set up for the person to make that correction and the amendment of their answer. It's just what we do in civil pleadings today. If we file a case and answers come in, it doesn't meet the necessary standards of the law, we file a motion for a more definite statement, and there will be then times set up, responses made, and the matter will proceed. So I felt comfortable enough saying, okay, for non-judicial, that would be a remedy that we have in the law, and the good faith of the district attorneys is they will follow that as a means of being certain everyone has the opportunity, if they wish, to appear before the magistrate and state their position. The other difference, of course, $25,000, above $25,000, there will be automatically a court proceeding. That's the main difference. You have what's called non-judicial. They give notice. The notice, they are to respond to that notice. If they don't do so, they can then go forward with the forfeiture. If it's above $25,000, there will automatically be a cause of action, we'll say, to have the forfeiture action proceed before the court and a magistrate. Those are two main differences. The rest of it, we've had a lot of discussion on the verbiage of it to be sure that we get to the areas we talk about as far as the accounting and making appropriate reports. You know, one of the big questions we've had in the past has come up quite often is getting the information where the public has an opportunity, if they wish, to go view records about what has happened in a office of either law enforcement or prosecuting attorneys as to funds and property received in a forfeiture. As I have stated, and I believe emphasized sufficiently, once the property goes into forfeiture and is acquired by law enforcement and prosecuting attorneys, it becomes public property. And as such, like everything else we have as far as accountability, it's required that there be shown accountability as to the receipt of that property and the use of the property, whether it be currency or real estate or automobiles, whatever the case may be. If the property is sold, there's accountability of that. That then converts it from, say, an automobile to currency, and there will be showing what happened and the money's received. It's just like on a ledger sheet, you have cash coming in starting the year, you have expenditures during the year, and then you have the year-end balance. That's what we're talking about, just regular ledger accounting. And so that information will be compiled by those agencies that receive either currency or property for an annual filing, which will be done as it currently is done with the Carl Vinson Institute. Is anyone here today from Carl Vinson? Thank you. I'm going to have you speak to us in a few minutes, if you would. But the Carl Vinson Institute will be the repository of all this information. They will also be the ones to help set up the forms to be used with the assistance of law enforcement and their prosecuting attorneys. Those forms are to have certain information, which is by the guidelines set out in the law, incorporated into the forms. So annually, the forms are prepared. I think one of the stumbling blocks we've had in the past is who actually has the responsibility to file this information. The law, although states sometimes the law enforcement or DAs may make it, there's also language that said the local governing bodies make it. So it was not always certain with whom that responsibility rested. So we cleared that up. It will be that agency that receives the property, uses the property, expends the money. They will make the reporting to the Carl Vinson Institute, where you'll have this public record information. Mr. Chairman, I think we've had in subcommittee, I know we had a number of amendments, and I'm not sure if the full committee wants to go through those, but we could talk about them. I do have a few more amendments, believe it or not, since our meeting with the subcommittee. We've had some further review and concerns with language. I've met with the prosecuting attorneys on numerous occasions, as has Ms. Travis in my behalf. I've also met with some sheriffs. I had Sheriff McLemore and Sheriff Griffin come speak with me in my office and express some interest in language that they had, and we've incorporated, and one of these, Sheriff Griffin, is that language that we talked about. I'm going to read it out in a minute when we get to it. But we've incorporated those changes. I've tried to be as really open and accepting of concerns that any agency had. I've worked with Mr. Rotondo, who is here, and Frank's representing the Chief of Police organization. I've listened to their comments. So I've been, as broad and open with anyone, including other legislators, of course, to try to come with a bill that I hopefully will see carrying forward with good public policy on this issue. I think there's I say this, one of the things I believe I'm down here to do is try and protect people's property. That doesn't mean to stop taking from those criminal elements who have property acquired wrongfully and have taken cash or currency and bought property wrongfully with their fruits of their crimes. That needs to be removed from them. But we do want to be sure that the Constitution and the laws of this state are there to protect those who feel innocent in these opportunities that are given, we'll say, to law enforcement and to prosecuting attorneys to take back property that was ill-gained. So, Mr. Chairman, I'm prepared to go forward whatever direction you wish me to take with a review of HB 1, but that is the general spirit of what is the purpose behind the bill.
Thank you, Mr. Chairman. Why don't we do this? Why don't we see if any members of the committee at this point have any general questions of you, and then I'll turn it back over to you to go through the amendments as you see fit, or describe things that were changed in the draft that we have for us, just so we're all talking off the same page here. I'm looking at LC number 29580S. Is that correct?
Yes, sir.
Okay, and then behind that there's a series of amendments that we'll get to their LC numbers when we come to those.
We have 3 additional amendments, right?
But before we go any further, any general questions from any members of the committee for the presenter of the bill today? If there are none, Mr. Chairman, we'll go back to you and let you go through the bill or the amendments as you see fit.
Since we've had such lengthy review and discussion, if there's anyone in the audience who would like to talk, address the committee, if I might ask, Mr. Chairman, does anyone want to?
We do have 4 signed up, Mr. Chairman. And you mentioned the gentleman from the Carl Vinson. Did you want him to come first?
Yes, sir, I do. I'd like to have him.
Is it Paul Burke? Is that right?
Sure is.
Come on up, Paul. Absolutely. Hold on. Press your button. Let me turn your mic on there. Okay, go ahead.
Are these the same amendments that we went over yesterday?
Yes. No, they've been incorporated into this particular current bill number.
Okay.
The ones we did yesterday in subcommittee.
Right, but that's what I was asking. We getting ready to go through those amendments again?
No, sir, we've already got those in here.
Okay.
There will be 3 additional.
Okay.
Mr. Burke, thank you for coming today. And where's the Carl Vinson Institute of Government?
University of Georgia.
Well, I'll be. Isn't that great? All right. Well, thank you so much for coming today, and we're welcome to have you. And the Carl Vinson does good work not only here for us at the legislature, but also for several of our local governments throughout the state. We appreciate your work.
Well, thank you, Mr. Chairman. Thank you very much. Mr. Chairman, we have been maintaining a website for several years at the Institute, and that website was started out providing information related to budgets and financial reports from local governments on their expenses, etc. And this also, with seizures and forfeitures, has also been part of the website. But as we've discussed, the reporting has been not universal and not in a universal format. So this bill, and with the work we've been discussing with staff, would allow for a format and a comprehensive approach to receiving the information. And one of the things that has not been available in the past has been any kind of, I guess we'd call it enforcement mechanism, perhaps,
yes.
To require the reports to come. So while we know the universe of the reports that could come to us, we don't get everything that could come to us. And in this way, there would be a nice approach to that aspect of getting the information to the Institute. So we put it on our website, and then it'd be available to the public to review that information. So, Mr. Chairman, we've enjoyed working with the committee on this so far, the staff. We've had some different conversations about what the form would look like. We know that under the current legislation, or the draft legislation that's going through, we know that there's also in there that we would be coordinating with the Office of the Attorney General, the prosecuting attorneys, as well as the Office of the Administrative Office of the Courts also. So we're looking forward to working with them in putting together this form, which would hopefully suit the committee. And
I want to personally thank you, Mr. Burke, and your entire organization. As Chairman Fleming says, y'all have been a great asset for the state. In this instance, you've been very helpful. We feel that this is again, continuing the right placement of this repository of information, and we do have some language in here now that gives the enforcement mechanisms to the prosecuting attorneys for the people in their jurisdiction to oversee that, be sure that they're done. And I think that's a good step in the right direction.
Thank you, Mr. Chairman. We look forward to working with you, the committee, legislature, on this process as it goes forward.
Thank you.
Thank you.
Any questions by members of the committee for Mr. Burks? Mr. Burks, thank you again so much for coming today. We certainly do appreciate it.
Thank you.
Okay, we have 3 other people signed up to discuss the bill, and the first one on the list is Wiley Griffin of the Georgia Sheriff's Association. Sheriff, you want to come forward? Okay. Sheriff, thank you for being with us today, and please introduce yourself, and we'd be happy to hear from you.
I'm Wiley Griffin, the sheriff in Decatur County, also vice president of the Georgia Sheriff's Association. I do want to thank Chairman Fleming and Chairman Willard, and also want the committee, thank the committee for allowing me to speak. And I want the committee to know that we did meet with Chairman Willard yesterday, President McLemore, and myself. He was very accommodating, and we went over some language and what we want to change, he changed for us. But unfortunately, we're going to oppose the bill. We had a board meeting this morning, and our organization is governed by a board of directors. And so what I would like to do is just read into the official record is what our stance is on that. And I'll give you this letter. The board of directors of the Georgia Sheriff's Association met this morning and upheld their position of opposition to House Bill 1. Our present asset forfeiture laws are workable, effective, and have been proven constitutional and upheld by our courts at all levels. Sheriff Bob McLemore, President of the Georgia Sheriff's Association.
Thank you, Sheriff. Any members of the committee have any questions of the Sheriff? Mr. Chairman?
Just to follow up, Sheriff Griffin, I don't know if you saw the draft, the language. Have you seen the draft language for that last section about if you have a chief officer of law enforcement leaving, being defeated or whatever as far as office? And I want to ask if you've seen that, if that's acceptable in its present format.
I did see that. I have seen that. I saw that this morning, and that's what you and I agreed on, and it was the exact language that we agreed on.
Okay.
Yeah, sure was.
Okay, we have one question from a committee member. Is it Chairman Weldon? Did you have a question? Okay, go ahead.
Sheriff, in that, I'd like to get a copy of that letter if I could.
It's just right up here for the record. We can get you a copy made. You want to see the original right now, or we're going to make you a copy?
Yeah,
now?
I would like to see the original
just
right now.
Just pass it to him right now.
It's my understanding that this bill was specifically held over from last year at the direct request of the Sheriff's Association and the sheriffs that were here. Is that you believe that to be true?
Yes, we did stand against the bill last year.
And specifically, I believe I may need to pose this question to Chairman Willard, if you don't mind, Mr. Chairman.
Absolutely. Go ahead.
Isn't it true, Mr. Willard, that this was held over from last year as a direct result of Sheriff's Association's concerns?
We had strong opposition from the Sheriff's Association. We felt best to hold up and try to review it further and get more involvement with agencies.
Okay. If I could, Mr. Chairman.
Please.
And Sheriff, have there not been many meetings throughout the year prior to the session in 2013 in order to try to resolve any issues that are related to this bill?
That would be a correct statement.
Okay. And it's the position of the Georgia Sheriff's Association that the present forfeiture asset forfeiture laws that are in place at this time are workable, and they're what you guys would prefer to proceed under, or the Sheriff's Association would proceed under going forward.
That is the Board of Directors' stance.
And if I could, Mr. Chairman.
Yes, sir.
The Sheriff's Association doesn't have any language that they would like to put in this bill that they're presenting in this letter that they provided here today. At least I don't see it.
No, sir, not this bill.
And there's nothing that they're offering to perfect the bill where they would be more comfortable with it or would be able to support the bill.
In all due respect, basically, the letter, is our stance.
And Sheriff, I just want to be clear. This letter that was provided today, and it's dated February 6, 2014, does not provide any recommendations on policy issues that are contained in the bill, or any language that they're requesting be included in this bill in order to assuage any concerns that the Sheriff's Association has.
You are correct.
Thanks, sir.
Thank you, Chairman Weldon. We have a question.
I do. I want to just follow
sure,
up
Mr. Chairman,
by
go
my
ahead.
friend Sheriff. And Sheriff Griffin, is it not true that we are not in the bill changing the seizure standards? Because what I'm saying is you have standards by which you determine as a law enforcement agency when there shall perhaps occur a seizure of cash and property. And the bill itself doesn't address, to your knowledge, any of those issues.
I'm very familiar with the bill, but
if that's not a fair question,
yeah, I'd just rather stand on what the official record statement is.
All right. I'm going to ask you one last question. Just as a personal matter, do you have a personal feeling about the bill as to things that you see bad or good, or what's your comments on the bill as a whole?
I'm going to stand with my sheriffs.
Okay. Thank you.
Representative Welch.
Yes, sir. Sheriff, thank you for being here. And I just wanted to ask a question. Did The board did the board discuss or interview or talk with, as a board, those 4 sheriffs that joined us over the summer to vet HB1 before they rendered this decision?
Well, let me answer it this way. I'm not familiar with all the 4 sheriffs. I know one of them, Mike Yeager, was there this morning, but those sheriffs have been included in our talks.
Okay.
And so they are very well aware, because they are part of the board.
Okay.
And I take that back. Some of those are not a part of the board. I won't take that back. Mike Yeager is a board director, and he was there this morning when this was discussed. And I can only assume these feelings were communicated to the people you're talking about, because I don't really know exactly who the other 3 were.
Okay. And
if you tell me, I'll tell you if they're there or not.
And thank you very much for, I don't remember all the names. I know Ralston, Sheriff Ralston was one.
He was there.
Beddick was one.
John Kerry Beddick was there this morning.
Okay. I just want to say thank you for allowing them to be there. I mean, I think they came and they were part of the process, and their input was very helpful.
Thank you.
Okay, Representative Evans.
Thank you, Mr. Chairman. Thank you, Sheriff, for being here. I had a question about the 4 members who were on the work group as well with us this summer. Did they, either in the meetings this morning or in any other conversations that you had with them or others that you know from the board, mention any specific changes that they had tried to offer throughout the work group process, or following up on that they were not able to get into the bill that led to the position of the Sheriff's Association?
That would really go back to, our board of directors' decision to oppose this bill and completely vote as a majority to we're happy with the bill that exists now, and we don't want to change.
Thank you.
Okay. Any further questions for the sheriff from members of the committee? Sheriff, thank you so much for coming today. We appreciate you being with us.
Thank you.
All right. Next on the list, I have our good friend, District Attorney Danny Porter. Danny, you want to come forward?
Thank you, Mr. Chairman. As the committee is well aware, last year I spoke vehemently in opposition to then HB1, and several times. But today I'm ready to say, if we could all open our hymnals to LC 295880-S, this bill is the result of a tremendous amount of work by members of this committee, members of the prosecuting attorney staff, and I would like to specifically thank Gary Bergman for his work on it. He helps keep me focused and in the weeds, I guess. I can speak on behalf of the prosecutors of the state. This is a bill that we have had a tremendous amount of input. Thank you, Mr. Chairman. We believe that this bill in its present form, and we've reviewed the amendments that are going to be offered today, we think that this bill does 3 major things, and they're important to the people of the state of Georgia. Number 1, it maintains a level or a burden of proof for the seizure of forfeited assets that is consistent with the civil case law. Second of all, we believe that it sets up parameters that control, in the case of prosecutors, that actually control spending of seizure assets for purposes that are put out in rules and regulations that are promulgated by the PAC. And third of all, it has the majority of the bill is the reporting section, and it will give the citizens of Georgia all the information they could ever want on what law enforcement is doing in terms of the seizure of individuals' property and how that is being used or not used or returned or whatever the disposition is. And I want to thank the members of the committee. This was a long haul. It was a heavy lift. And the contributions of the members of this committee are inestimable. And we would recommend that this bill be passed. And we would also say, in regard to the amendments, I know I'm speaking a little bit out of order, but we've taken a look at those, and we think that they're appropriate to the bill.
Okay. Thank you, Mr. District Attorney. I think we have one question for you. Chairman Weldon, do you have a question?
Cross-examination.
Are you aware, have you had opportunity to work with the Sheriff's Association regarding the House Bill 1 and when it was filed last year and as it has progressed through the committee process in 2013 to today?
Indirectly. I have not spoken to members of the Sheriff's Association. It has been communicated to me through Mr. Spahos, who is the Executive Director of the Prosecuting Attorney's Council, who is not here. He's outside, but he has spoken directly to some of the representatives. I think the concern of the sheriffs in general is that some of their opinions were not considered during the working group meetings, and that's what's been expressed. I can only say that.
Okay. Thanks, sir.
Let me ask you one thing that I was touching on with Sheriff Griffin. As far as the standards of what is done in the seizure of property, this bill doesn't touch on that area, does it?
It does not change the current law standard of what.
So how they go through seizure, on what standards and circumstances may apply to the seizure of property,
yes.
That is not changed.
It is not changed from current law. This bill, current law allows, and this bill would allow, law enforcement can seize property based on a standard of probable cause. If the state can prove by a preponderance of the evidence that it was used for an illegal purpose, then it can be forfeited to the state or to the local governing body.
And what the law of this particular change is doing is bringing, I call, a central format of what we call the procedures to be followed when there would be a forfeiture, which is really done by only the prosecuting attorneys, correct?
The actual documents are filed by prosecuting attorneys, yes, sir. But I think you touch on another important advantage to House Bill 1 by substitution is that there are a number of provisions of current law with everything from habitual violator to drug trafficking to Medicare fraud to firearms, certain types of firearms possession, which allow for the forfeiture of property. This unifies all of those statutes under one procedure, under one way of doing it, and we think that's going to present an advantage both to prosecutors and to claimants, because we'll all know nobody's going to get tripped up by the procedure just because it happens to be in the code section.
And the position of the Prosecuting Attorney's Council is support of the bill as amended.
Yes, sir, including the amendments that.
Yes, sir. I mean, to be amended. Yeah.
We've looked at those, and a good example of that is, without preempting you, in one of your amendments, while we were doing all this, we discovered one forfeiture provision that we left out of the bill, which was Medicare fraud, and so we've included it in the bill. So it gives you an idea of how far flung some of this forfeiture stuff was.
Okay. Representative Caldwell.
D.A. Porter, I think you touched on my question that I had already punched my button when you started talking, but forfeiture is not just for drug transactions, but it involves many different criminal violations, and those violations are scattered through the code in probably 10 different sections and not all in the same book.
That's correct.
Code section.
I think it's actually 14.
Though I said 10, I was close, and I was guessing. This codifies them all into one place so that if the Sheriff's Department, Police Department, as you say, wants to forfeit a car for habitual violator, there's even you can even do it for prostitution. You can do it for another gambit of things. They're all now in one place, and none of those have been changed, have they?
No, sir. No, sir. Actually, we've included all of the offenses which can result in the forfeiture of property into House Bill 1. And Mr. Bergman informed me he can't stand it when I make a guess. There are 34 in the code that could subject to forfeiture.
Wow.
He doesn't like.
I wasn't even close with my 10 then.
He doesn't like me ballparking it, so there were actually 34 offenses.
But they are all now in one place that one person can find by looking in one code section, and they have not been changed at all. They just put in a different place.
They have not been changed at
Thank
all.
you.
They've just been put under the civil
Procedurally, yeah.
Okay. And Representative Evans?
Thank you, Mr. Chairman. Thank you for being here, and thank you for all your work throughout this process. You had mentioned that you had either directly or indirectly talked to some of the sheriffs who mentioned that they did not feel like their changes were considered or incorporated during the working group, and I was wondering if you could share with the committee if they had shared with you any specific things that they thought were not added.
Representative, I don't have any of that. I don't have any of that information. I just know that it was expressed to me they had a feeling that their concerns were not being listened to or were not listened to, and that's all I know.
Okay, thank you.
Okay. And Representative Jones?
Chair, Honorable Porter, and you may have covered this while I had to step out. Is there anything in here that requires the persons whose property was seized to file a document or lose that right? So I read through the portion where you all have 30 days and then 60 days from there.
If the state decides to proceed with a non-judicial forfeiture up to $25,000, then what the new bill provides is that if a person files any type of claim in writing, then the state will be required to file a full judicial forfeiture, which requires notice of service. And then if the person comes back with an answer that is deemed to be insufficient, the state can file a motion. I don't remember specifically what we called it, but it's a motion for clarification of the answer or to cure the defect. And it's kind of like a foundation objection, is that if I want you to clarify your answer, then what I have to do is tell you where your answer is deficient or where I believe it is, and a court can order the defendant to cure the defect.
What's the time on that the person has to make that
I
file?
believe it was 30 days. 15
quickly,
they have 15 days to cure the defect.
Or longer if the court.
Or longer if the court decides.
And I'm sorry, and what's the requirement for the initial filing by the person whose property is seized? How long do they have?
If you file an administrative forfeiture, then you have to proceed to forfeiture within 60 days, and there's not a specific mention of when that claimant has to come in. If they come in prior to the order of forfeiture, then that would immediately stop the proceeding and move it over to a judicial forfeiture.
They could file something, I think I've heard it referenced on the back of a napkin and give that to the DA.
That's the intent of the DAs, and that's what we intended when any claim. We did ask that it be placed in writing, but it would be any claim that to the property would immediately halt the administrative and move us to a judicial forfeiture.
Any further questions of the committee of Mr. Porter? Mr. Porter, thank you so much for coming to be with us today. We appreciate your help as always. Okay. Mr. Chairman, we no longer have anybody to sign up on the list here to speak, so I think we're back to the committee itself and your presentation as to how you want to proceed, whether you want to talk about changes in the bill or amendments. You go as you see fit.
Well, I want to again thank all the participants, those on the Ralston Committee, the Prosecuting Attorneys Council, and the sheriffs. I'm sorry, I'm saddened to hear if they feel they were not being allowed to express themselves or whatever. If that's the case, we who sat here were having a full open discussion. I felt the whole time from anyone and everyone that was serving on the committee. So where they expressed information they wanted to provide about the bill, I thought they were given full opportunity for hearing on it. If they feel otherwise, I'm saddened to hear that. Mr. Chairman, at this time, I would like to move for the adoption and acceptance of LC 295880S of House Bill 1 as a committee substitute.
There is a motion. Is there a second? There's a second by Chairman Weldon. Discussion on the bill. Mr. Chairman.
Mr. Chairman, I'd like to offer amendments, if we might, at this time, if the chair is open for amendments. We have 3 amendments. I'll read them by amendment number and explain the purpose of the amendment. We have AM 292255. We have language currently, if you look on page 22, thank you, Ms. Travis, that deals with a issue that was really brought mostly as a concern by the sheriffs and we were addressing that initially even, and the language dealt with the circumstances of a chief law enforcement officer either not qualifying or being defeated for election, and we have some language currently in the bill that was not to the liking specifically of the Sheriff's Association. And speaking with Sheriff Griffin and Sheriff McLemore, I told them I'll get it put into better language to their satisfaction, and that's what this does. I'll read it out loud for the benefit of the audience. This is changing what is line 737 to 740 of the substitute bill, subparagraph 4. When a chief officer of a law enforcement agency does not qualify as a candidate for re-election or has been defeated in any election, he or she shall not transfer any currency or property received due to civil forfeiture proceedings to any other entity prior to leaving office, provided, however, that he or she may continue to expend such currency or make such use of property for any official law enforcement purpose within his or her law enforcement agency. And I think that reads on. That I offer as amendment, first Willard amendment.
There is a motion and there is a second. Discussion on the amendment. Any questions of the chairman regarding what is AM 29225? The chair hearing no questions or discussion. All those in favor, please indicate by saying aye. Aye. Any opposed? The amendment is adopted.
Thank you, Mr. Chairman. I'll offer amendment number 2 is AM 292258. This gets into the reporting standards and requirements under the law, addressing how it's to be done, and the prosecuting attorney council, after reviewing what we had put through yesterday, had some minor tweaking of language. I'd have to call Ms. Travis to give us the specifics. I don't think anything major was changed. It's more of a tweaking to be sure we had clarified as to currency and types of property, whether it be property that has been sold or property retained.
Also, Mr. Chairman, we tried to clearly define between the seizing agency's report and other agencies.
Correct. And we want to be sure, because sometimes they want to give property to a third party, such as maybe a school district, when they have, as they refer to, grower lights and other equipment of that nature that might benefit the school district, may not have much monetary value per se in trying to sell or dispose of it, but could have great use to the schools. And so there is ability for them to make those type of transfers, which I don't believe actually exists under the current law. I think it's been done, but it just wasn't permitted by the law. So we do have recognition now in the law that the law enforcement agencies, if necessary, and the prosecuting attorneys, when desired, they can make transfers to other entities that are defined as being such things as school districts and local governments. I move for adoption of AM 292258, Mr. Chairman.
There is a motion and there is a second. Any questions or discussion regarding the amendment? The chair hearing none, will vote on the amendment. All those in favor, please indicate by saying aye.
Aye.
Any opposed by no? The amendment passes. AM 292258.
Mr. Chairman, the next and last amendment we have is AM 292257. This is a lengthy amendment, but if you look at the length of it, it is really just striking out a lot of existing law that is no longer necessary, because here again we had a separate statutory procedure set up that went to the purpose of how you would go through a forfeiture dealing with Medicare fraud. We don't need that anymore. Medicaid fraud, as anything else, if there is to be a forfeiture, we've got a general statute under Civil Practice Act that will be covering it. So we've struck through all this. So we're really, I think, one of the things we're doing is, of course, eliminating law, but giving us, as District Attorney Porter pointed out, a common general provision that everybody can look to and know what the standards are, how it's to be done. So we struck through all that and bringing in, by this lengthy amendment, the Medicare fraud forfeiture statute as part of the proceedings we'll do under the House Bill 1. And I move for the adoption of AM 292257.
There's a motion and there's a second for that adoption. Any questions or discussion from the committee members on AM 292257? The chair hearing none. All those in favor, please indicate your support of the amendment by saying aye. Aye. Any opposed by no? The amendment is adopted.
Mr. Chairman, before we take a vote as to the House Bill 1 as a committee substitute, I want to take a moment, as I did yesterday, and recognize the great work that we received from a staff member of the Legislative Council's office, Ms. Jill Travis. I don't know if things that we've put together, I have in the last few years, could ever have been accomplished, whether it be the bill we had on the evidence code, the bills last year that I carried that have great, I think, importance to the state, but took the drafting and knowledge of how to do this work with the detail and attention that we get from Ms. Travis. And I'd like to stop and personally recognize her and thank her again, as I do not often enough, but from time to time, because she is really one of the greatest assets we have in the legislature. And so, Ms. Travis, personally, and I hope on behalf of the entire committee, accept our sincere thanks and continuing gratitude for all that you do for us. Yeah. Great job. In closing that out, Mr. Chairman, I would like to call for the committee's consideration of House Bill 1 as amended as a committee substitute.
We have a motion and a second to pass House HB 1 by a committee substitute as amended by the committee. Discussion or questions from the members. Representative Evans? Representative Stevenson?
Mine, Mr. Chair. Thank you. To the Chair, I did not serve on the committee, so I want to make a comment of why I'm going to vote for this bill. Last year under House Bill 1, we had a lot of discussion. I listened and I vehemently opposed this bill along with my sheriffs in the 3 counties that I represent, as well as the district attorneys of those counties. I believe we went a long ways and worked really hard in harmonizing everyone's perspective. To the extent that it may not make everyone happy, it has shown what we can do when all entities work together. So for those reasons, for my colleagues that worked on the bill and for the people that united in favor of the bill, I'm going to vote yes on it.
Thank you. All right. Representative Welch?
Yes, I want to echo those thoughts. I was fortunate to serve on the Ralston committee, and it was indeed a pleasure to watch that committee of legislators and prosecuting attorneys and sheriffs work line by line on every section of the bill. At least 2 hours out of 3 meetings that we had spent. I think Wendell, I think you bought us a lunch at the last one, and we had a good long discussion.
Steak.
And I think we had it was amazing to watch the discourse. The chairman clearly allowed all opinions to be expressed in every way, shape, or form. Allowed for all questions to be asked and points to be debated by all members. And allowed for everyone to, at any time, to make amendments as they saw fit and to vote on those amendments and approve them. And I very much appreciated that. Thank you.
Thank you.
Okay. Any other committee members wish to comment or have any questions regarding the bill before we vote on the committee substitute as amended? All right. Hearing no further questions, there is a motion for due pass on HB 1 LC 29558. 0S as amended by committee substitute. All those in favor, please indicate by saying aye.
Aye.
All those opposed by no. The bill carries.
Thank you, committee.
Thank you, Mr. Chairman. Will you
We'll
take this back now?
Yes, sir. We'll just continue on. We're going to have 2 other bills. Consideration. Yeah, I do that. Yeah. Thank you. All right. Get my worksheet up here. Next we have on our calendar will be House Bill 820, which is LC 295864. And Representative Powell, you will be offering that bill, I believe. Yes, sir. There you are. Look around, please.
Thank you, Mr. Chairman.
Oh, we'll get your mic on. I'm sorry.
Thank you, Mr. Chairman. Briefly, the current state of the law in Georgia is that a condominium association has the power to file a litigation proceeding against a developer who perhaps has some issues of maintenance or improper construction as to the common areas of a condominium. There have been situations where developers, prior to turning over the condominium and while they controlled the condominium association before there were enough members for them to turn it over to the members, have put in into the condominium homeowners association documents provisions that prohibited the developer from being sued, and so that has circumvented this at a time when the homeowners did not have any say-so in the matter. And all this bill does is it makes it clear that any waiver of the right to sue that is put into the homeowner association documents during the time that the developer is in control of the condominium association will not be valid. And so all this does is, if the homeowners later want to put such a provision in, they can. The other thing that we put in here was we made it clear, because there's another statute that deals with the when there is an issue of repair, that certain things have to be done before people file suit, that they have to communicate with each other. And that particular provision we are not circumventing here. We still want to make sure that owners and builders have those discussions before they file suit. And so we specifically set forth that this does not circumvent the obligations of that code section. And I'd be happy to answer any questions, Mr. Chairman.
Thank you, sir. Thank you very much, Mr. Powell. Any members of the committee have questions? May I inquire, Mr. Powell, this came through subcommittee?
Yes, sir.
Which subcommittee was it heard by?
Jacobs Subcommittee.
And at the Jacobs Subcommittee, Mr. Jacobs, did you have any input by anyone who had concerns or questions regarding the application of this provision for condominiums?
No, we had no testimony against the bill or expressing any concern about it. Some concerns have been raised after the fact. I'm trying to kind of synthesize those with the language that we included there in subsection I. And we may hear some testimony on the bill today. I don't know if anyone signed up, but I tend to think that subsection I covers it. We did make some amendments to the bill, including inserting that subsection I, but I think it's in good shape.
All right, and the subsection I says that this code section shall not alter, modify, or remove the association's obligation to comply with Part 2A of Article 1, Chapter 2 of Title 8. What does that provision
It
state?
deals with, well, I mean, it's an entire part of the
Yes,
code
sir.
that has a number of requirements in it, but it deals with resolution of construction defects by a condominium association. So, generally speaking, and has a number of
And
requirements.
that is the, what we call it, the right to, what's the term I'm looking for? This is right to repair. That's it, yeah. So there still is that standing right as far as the developer of the complex to do the repair work.
Correct.
Without being potentially in a litigation situation.
Correct.
Okay.
And Mr. Chairman, I don't, and certainly in the chair's discretion, but Mr. Bowers did bring some concerns to me after the subcommittee meeting. You may want to at least hear them out before.
Sure,
we
we're
pass
going
the
to
bill on.
we'll call for public comment.
Sounds good.
Thank you. And, have that done. Is there anyone who would like to address the committee regarding House Bill 820? No one wants to address the committee. All right. Mr. Powell, what's your pleasure?
My pleasure is due pass.
You want to make a motion? I'm open to a motion, Mr. Powell.
I make a motion due pass.
Motion due pass by Mr. Powell has been seconded. Is there a discussion on the motion? No discussion. Are there any amendments? There are no amendments. The chair will call the main question. All in favor of due pass, House Bill 820. I'm sorry. What did you say?
He asked.
Did you hear from who? We asked. He said he passed. He passed. I was rolling there for a minute. Now you got me off my track. All in favor of HB 820 as is it a committee substitute signify by saying aye. Aye. Opposed, like sign. One abstention. All right. So note the abstention, and we have a due pass. HB 820. Next bill we have is going to be HB 449. Mr. Gravely, if you're present. Please come forward, Mr. Gravely. I'm sorry to have you held up. I felt this may take a few minutes, so we'll get that short one I thought out of the way.
Yes, sir.
So if those want to leave. Let that quiet down before we start. We'll get the door closed, and with anyone else want to leave, please do so, and we'll shut the door. All right, Mr. Gravely, would you like to tell us about House Bill 449, please?
Yes, sir. Thank you, Mr. Chairman, members of the committee. House Bill 449 is a bill to address a situation that the genesis thereof started in Douglas County in 2009, but has happened across the state of Georgia. And I have brought with me several, my own, not my personal, my county's 911 director and some of his colleagues to speak for the bill as well. But in 2009, we were affected, many of you may know, by the 500-year flood in Douglas and Fulton County.
Oh, here this is.
While some folks had lost property or were inconvenienced in travel back and forth to work, others suffered unthinkable tragedy because they lost the life of a loved one. And in the fashion or in the way that they lost the loved one is what this bill seeks to address. We had a young lady who was traveling home from work one night, was swept off due to a current over the Sweetwater Creek, dialed 911, which she ravined down into the ditch, dialed 911, and for 22 minutes, that phone conversation was recorded by the 911 dispatcher. Her cries for help, praying back and forth with the individual, trying to get officers and emergency personnel on the scene. Unfortunately, she did succumb to the waters and drowned in the car on the call with a live operator on the other side. The bill will address that particular call in the fashion that it wasn't too long after that my 911 director, Mr. Greg Whitaker, received a call from a media outlet requesting that particular call. And it, much to his shock and then shock of our other local officials, who had at that time refused to release the call. However, he did do the work to capture the call. The open record fee was charged, and in the end, the agency decided not to purchase or pay the cost for the call. The bill, to begin with, had started out, it was a very broad measure, and with the help of Representative Evans, Chairman Jacobs, and Mrs. Travis, I believe has been narrowed down. We've addressed the concerns. It was a very thorough vetting in Chairman Jacobs' subcommittee to where I believe what we're doing here, the finished product actually addresses what happened that night, and it would seek to prohibit the public disclosure of a 911 call where the caller dies during the call. We had rape or aggravated battery. That's already covered when you get into a criminal investigation. Your sheriff or your police chief could, during pending investigation. So we narrowed that. We removed that language.
They still get them later.
They still get
them later once the
Yes.
investigation is completed, but they, as of that point in time,
Yes.
you're right.
Yes, sir, Mr. Chairman, you are correct. Representative Evans, also I appreciate her language providing for civil action. So the bill that we have here, I believe, is a good product. The bill is being supported by the Georgia Chiefs Association, the Georgia Association of Solicitors, ACCG, and the Georgia Commission on Sexual Violence. At this time, I would entertain any questions or thoughts from the committee.
Let me comment that the one of the things that this committee receives quite often are bills dealing with the open records and sunshine laws that we have in place in Georgia. We zealously protect that right, which is a public right to records.
Yes, sir.
But I think there is a line as far as good taste and just the right of some privacy of someone, in this instance, certainly in the dying moment, not have to have that become a public document. I find it appropriate to say in other cases you talk about with criminal conduct, it may be held up for a time while it's going through the investigation stage, and even perhaps up through the prosecution if necessary, but it does become public record.
Yes, sir.
At a point in time. So with this, I think there's just a line that's appropriate to be drawn as to really what is good taste in allowing somebody to have that type of access.
Thank you, Mr. Chairman.
Questions over the side here? Yes, ma'am.
Hello, Representative Bradley. One question from my constituents and one question from me. The main question I received is, does this negatively affect groups like ACLU, NAACP, other advocacy groups that oftentimes do their own investigations to help out in a number of cases? They may not be someone's civil or criminal attorney. How would this affect them?
Well, if they are not one of the established parties, and it says, and if you look on line 17, paragraph C, the following, provided that the person seeking the 911 audio recording submits a sworn affidavit that attests to the facts necessary to establish eligibility under this subparagraph. The caller or representative of the deceased caller's estate, the parent or legal guardian of the minor caller, a legal representative of a party to a civil action when in the good faith belief. I mean, if they are under one of those express definitions. Now, if the family, let's say the family was not happy with the local law enforcement's investigation, they wanted to reach out to a third-party group and the legal counsel at that point, my understanding is that Representative Evans' language would provide for that if there was a civil action that they wanted to pursue. Yes, go ahead.
That's correct, but I also think because it would probably be the family that would be engaging in services, the family always has the right to get the call.
Absolutely.
Whether that group has lawyers or not.
Okay.
Thank you. And the second question, Chair.
Yes, ma'am.
And this
Go
may
ahead,
be just way down the slippery slope, but the language says the caller who died during the call or some other person. You all remember the most recent case, Trayvon Martin. The argument was who was really yelling in the background. Is there any way to potentially, you see the potential problem with that? If you have more than one person yelling, then who's trying to get the information, things of that sort. I don't know if there's a case where that would even be relevant, but I just want to know if that had been considered.
I think that the subcommittee had considered all possible options and looked into the possibility of exactly what type of slippery slope could happen, or a scenario that could happen that would present a problem, and determine that this particular language here, after the reviews and edits of the subcommittee, would be sufficient.
Next question, Ms. Evans, or no, I'm sorry, Ms. Weldon.
Thank you, Mr. Chairman. To the author of the bill.
Yes, sir.
think the bill in lines 9 through 12 provides that a telephone call made to 911 would not be subject to disclosure unless that person is law enforcement, to the accused or the accused attorneys in a criminal case.
You on line 13? Representative Wells?
Well, if you look at line, the call's not open. Well, let me back up. The call is not open to disclosure, public disclosure, if the caller died or some other person died during the call, or if the caller was a minor, and then it says the following people are can get a hold of it: the caller, a representative of the caller's estate, the paralegal guardian of a minor caller, or a legal representative of a party to a civil action when in good faith belief the legal representative of the caller is relevant to a civil action. What about the legal representative of the other person who died, which is referred to at the end of line 11? It says some other person who died during the call.
So what you're saying is that other person is not defined or represented in between lines 21 or line 20 to 27, correct? Is that what you're?
Yeah, I'm just asking about it, yes. Is that? Am I missing? Am I just looking over that in the law? If I would, okay. What if they? And I guess my question is, what if a civil action hasn't been filed yet, but the person is trying to figure out?
Was it on 23?
Oh,
I didn't 23. A legal representative of a party to a civil action. That would be covered in that right there.
I didn't see page 2. So, well, and this is a legal representative of a person who may pursue a civil action when in the good faith belief of the legal representative.
We may have a motion that might resolve something in a moment.
Yes,
Mr. Weldon?
Yes.
Please. I'm looking at this. I'm concerned about how who's going to address this issue of the caller coming back asking for this tape of his conversation with his deceased.
Well, I was trying to figure out how that would happen as well.
Mr. Jacobs, I'll entertain a motion from you.
I'm still
I thought I asked.
Oh, sorry.
You
All right,
you
there
want
we
to
go.
make a motion?
No, I had the wrong microphone. Yes, and I'll preface this by saying that I would certainly encourage members of the full committee, if you have any way that you would like to change the list of people who may obtain the 911 call, please do consult with me, prior to the end of this week. We'll probably hear this bill again next week, but the motion is to recommit the bill back to subcommittee.
Is that motion seconded? Second. And any debate on the motion? Now we'll call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. What I would suggest, I didn't mean to cut off Mr. Gravely, but
yes, sir.
We've got some language here that needs to be better addressed before we get the full committee's consideration. I think we need to let subcommittee re-examine this bill.
Yes, sir. Thank you, Mr. Chairman.
Thank you, too. With that, I believe we've concluded, unless someone has a desire to address the committee on anything else today.
It's
night gallery.
Yeah, I didn't catch that one.
We'll stand adjourned.